So you've hired a personal injury attorney, and you probably have some questions about the expectations, what you're expected to do, and what the attorney is expected to do, and what does this process look like? So today, Derek and I are going to have a little conversation so that you can have a better understanding of what this all means. Derek, how you doing?
Not too bad.
Well, good morning, sir.
Good morning to you.
Good to have you back in here. It's been a while.
It has been a while.
Far too long. Made a couple changes, very small, but
Looks good.
still looks good. Yeah. So let's talk about what someone can expect after they've hired an attorney.
Okay.
So try as we might to explain that process when we initially encounter a client. There's always questions afterwards.
Of course.
And there's always a question of what a client should be doing, what the attorney should be doing, what the process looks like, and especially coming out of the gate. So I want to ask you some questions so that we can help people better understand that.
Okay.
For instance, let's talk about first steps.
Okay.
So you just hired an attorney. What are the first things that you need to do as the client?
Okay. So let's assume here we're talking about a personal injury case, like an auto accident or something like that.
Sure.
So initially, the first thing to think about right after the days following hiring your attorney is just not to talk to an insurance company. Your attorney should be right out of the gate informing the insurance companies involved of their representation. The problem is sometimes there is a delay there. That could be days, maybe even a week before the information of the representation of an attorney gets to the actual claim handler that you may have been dealing with before.
Why is that?
And sometimes it's a delay within the insurance company. You know, something gets faxed in and it gets passed around and sits on someone's desk. Sometimes, you know, you and I have talked about it possibly could be, you know, not necessarily malicious, but on purpose, that they just don't realize that you're represented. And you know, you may have already been, you as the client, I'm going to use you a lot as the client. You may have already been in contact with an adjuster. You may have already been talking about fixing your car or you know, your property damage. And so you may have already been in contact with that adjuster. You may have already gotten some things in the mail. You may have gotten a questionnaire about your medical treatment. You may have gotten a release for them to get your medical records. So there's different things that you may have already gotten in the mail. And so it's critical after you've hired an attorney basically just to cut off all contact with any insurance company, even your own, if you have, say, like I said, a property damage claim or something like that. Because we've had cases where, you know, after hiring us, they've received something in the mail, the clients receive something in the mail, and they think, oh, it must be okay for me to respond to this.
Because they've talked to a lawyer.
Because they've talked to the lawyer, and they just assume that as soon as they walk out of our office doors that everything coming from an insurance company is going to be approved or cleared by us. So the big thing is just in those first few days, the first step is just to continue to not contact or be in contact with the insurance company. And at least until, like I said, you know, they recognize our representation or your attorney's representation.
So once you cut off contact with the insurance company, you expect the attorney to handle everything. But how does the client engage and help the attorney? Because it's really up to the client in some cases to help provide the evidence the attorney needs to do their job.
Certainly.
So what sort of things should the client be documenting and providing to the attorney?
Okay. Well, you kind of said it. Our client is the primary source of all the evidence in a personal injury case. They're the only person who can talk about their injuries. They're the only person usually that was in the accident or maybe one of several people in an accident, but they're the source. And so you probably, as the client, have already explained most of that information to the attorney in the initial consultation. The facts leading up to the accident, how the accident occurred. You've usually provided all of that. You've usually provided your initial medical care, where you went to the ER, if you went to the ER, things like that. But there may be things that you remember later on, okay? And it's really critical to try and write that stuff down now. You know, or if something comes to your mind and you think maybe that is relevant, well, it probably is. And so you need to inform your attorney. But we see that making notes while it's fresh in your mind can really come back and serve well if this case goes into litigation. Because, you know, maybe months or maybe even years down the road, you may be called to testify on these things. So it's nice to remember, what was the weather like that day? You know, what was the traffic like? You know, was there anything weird going on, such as a traffic light being out things that you might not recall later on down the line. And then as you progress through the case, the client also is going to be building evidence for us based on their medical treatment. So sometimes we've had clients who have made notes or kept a journal during their treatment. And we can get into that a little bit more about medical treatment, but, that can also help, again, serving down the road, because you may not recall exactly how your treatment affected your daily life, or you may not recall how difficult it was to do the physical therapy. Mm-hmm. And so being able to just keep a note of that, keeping track of your pain, anything like that, anything that you think could be helpful for your attorney, it's good to get that information to your attorney. Yeah. But then also sometimes it's good just to make notes, even if it's, just really quickly on your phone or just jotting down things that you may not remember in the future. So,
yeah, I think all that's important. And I think people have to remember that a lot of times the way that an injury affects someone isn't going to be a part of the medical record.
Oh, exactly.
Because the medical record is going to be very objective. So the medical record may not say, well, this knee injury prevented someone from doing their household chores, or this knee injury prevented someone from going to their grandkids' soccer games, or this knee injury prevented them from going on golfing trips. And those are all important because the way that an injury affects someone and affects their life becomes compensable to some degree in the form of their damages. So, and the attorney isn't going to know those things unless the client provides that information.
Exactly.
And journaling is a great way to do it. Mm-hmm. And then, turning over those notes to the attorney at some point. What about pictures and video? Where can those be helpful?
Oh, those can definitely be helpful. And, usually in the initial consultation, we're going to discuss if there's any photos that you have of the scene or photos of your car or anything like that, or anything that you may have. Of course, the attorney is going to get as much evidence as they can throughout the whole process from, say, investigating officers or anything like that was on the scene. But anything that the client has is definitely going to be relevant. And a lot of times after that initial consultation, we'll set up a format for them to get all that to us. Mm-hmm. Those photos and stuff, so that we can record them and save them in our files, so that if someone loses their phone or anything like that, we can have those safely saved.
Yeah, and in addition to the property damage, I think, if there's a visible injury or bruising, mm-hmm. or if someone's in the hospital, if someone has a cast, if there's a surgery, mm-hmm. getting pictures of, sutures or braces or casts or anything like that. And the other thing that's really compelling, I think, is videos of physical therapy. Mm-hmm. To the layperson, I don't think there's a strong realization as to what physical therapy actually is.
Yeah.
Or how painful it can be, especially after, say, a rotator cuff repair. Mm-hmm. That's a very painful process. And if there's a video of that process, it helps describe it because, well, you don't have to describe it. It's on video. Mm-hmm. Physical therapy otherwise sounds like something that might actually be enjoyable.
Yeah.
It's not.
No.
I think it's a good idea to have video of that as well.
Usually, unless you've gone through it, mm-hmm. you don't understand how difficult some of those exercises may be.
Yeah.
And that's why I was saying,
and how you have to, there's a wall of pain a lot of times that someone just has to push through. And that's
exactly
obviously very painful. Let's talk, speaking of medical treatment, let's mm-hmm. talk a little bit more about that. And a question that I often encounter is, do I need to have my medical treatment approved?
Yes. Or
some folks almost assume that they have to have their medical treatment approved by somebody.
Yeah.
And so they wait.
Mm-hmm.
What should someone be doing with regards to their medical treatment?
So when you've hired an attorney, hopefully you now have the peace of mind knowing that, let's just say, all your rights are protected and that the business end of your claim with an insurance company is going to be taken care of. And that peace of mind should allow you to focus on yourself. Mm-hmm. A lot of times we tell clients that their focus is just to get better and we'll take care of everything else. And so that's the first thing to do, is really just focus on yourself. Now that should include also just following doctor's orders mm-hmm. and going and getting the treatment that you feel you need, just as if the accident never happened.
Right.
If you just hurt yourself in some other way, just treating it like that, going to the doctor, following the doctor's orders, going to treatment centers if you need to, or, go to, specialists or whatever a doctor may require or request of you to do. So just following doctor's orders, and doing what is best for your body. Okay. Yeah. And I would add there too, though, when you're going through this, it's also critical for the client to keep up with those appointments. If you have something and you have to miss an appointment, that's one thing, but we don't need unexplained gaps in treatment. Because unfortunately, insurance companies and ultimately juries, that opens the door for them to have doubt as to whether or not you were injured or how severely you may have been injured. So it's critical to be following the doctor's orders, but also to be going to your appointments as you can, obviously. And then the final thing I would say, too, is just you have to update your attorney as to where you go.
Yeah.
We have to order medical records. We have to request those medical records, and those medical records are a critical part of our evidence for a case. So we have to make sure that we know where you go. So that's kind of the responsibilities I would say on the client, or what they should kind of keep an eye on is, one, just do what you think is best for your body, but also keep us updated and make sure that you're following your doctor's orders and doing what you can in a timely manner so that we don't have any kind of arguments that we have to make, to try to spin anything like that, like an unexplained gap in treatment.
Yeah. And I think it's important to remember that if you're injured as a result of someone else's negligence, you don't have to wait for anyone to go get medical treatment.
Nope.
You can go get the treatment that you think you need
exactly
that will benefit you and help you overcome your injury.
An auto accident is not like a workers' comp claim.
Yeah.
A workers' comp claim is controlled like that. But an accident claim, like you just said, it's your body. You do what you would see fit, and then we'll compile everything and send it off to the responsible party.
And I think it's also important to remember that if someone is not seeking treatment, and you alluded to this with the gaps in treatment, and this is where the assumption comes in. If someone is not seeking treatment, the assumption is that they're not hurt.
Yeah.
And unless there's evidence to the contrary, you can't really overcome that.
Exactly.
The medical records are the evidence that someone is hurt.
Exactly.
And so when treatment ends, or it doesn't occur, or there's a large gap in treatment, there's no evidence that that person was hurt during that time. And so I think it's important to remember that we always have the burden of proof. We have to prove that the injury exists.
Exactly.
We have to prove that the injury continues to exist if it's unresolved. And when someone is released from care, if there's no other indicators, the assumption is that when they were released because they're back to normal.
Yeah.
And so it's important to communicate that to the attorney as well. So if someone is released from care, they may not necessarily be well. They might not have improved to 100%. But unless that's communicated and we figure out a way to properly document it, the assumption is that the day that they were released, that means they were good. That's it. That's the end. So I think that's important too. So coming out of the gate, we've kind of talked about that. What are the things that might occur in the first few weeks after an auto accident, for instance, after you've hired an attorney?
Okay. This is really good to touch on because those first few weeks or maybe the first month after hiring an attorney, you're not going to really hear a lot from your attorney other than possibly if we're settling your property damage or working with you to get your car out of a shop and get you in a rental car, things like that. But as far as the injury portion, there's not a ton of, I'm not going to say communication, but there's not a lot of movement really because you're still treating most likely as the client and we're also building our case. But during that time, your attorney is going to be communicating with all the parties involved. That may be insurance carriers for the at-fault party, your insurance carrier, other insurance carriers if multiple vehicles are involved. Your attorney is also going to be beginning the investigation and building your case. That would include reaching out to law enforcement agencies to get any evidence they may have, or if we need to employ a private investigator to seek out additional evidence and things like that. So building the case is happening. And then at the same time, kind of running concurrently, we'll also be ordering medical records. So as the client will clear certain treatment providers, say like an ER, say if they, from the scene of the accident, are taken by ambulance to the emergency room, they're probably not going to go back to the emergency room. They may have now moved on to a specialist or something like that. So we'll go ahead and get the ball rolling, getting those medical records, requested. But I would say most likely in that first month, your attorney's priority is going to be getting you back into your vehicle. Okay, that may be getting it repaired, or it may be having it, if it's a total loss, having it evaluated and getting you paid for your property. We all know that transportation is a critical need, and so most of us don't have multiple vehicles and things like that. So that's going to be the first thing we're kind of hitting the ground running, is getting you back into your vehicle so you have a little bit of sense of normalcy in your life, and you're not riding around in a rental car or sometimes, without any vehicle at all. So that's going to be the first month there is going to be we're building the case, we're getting all the parties involved, making sure that they understand that you're represented and things like that, and then focusing on that property damage.
Yeah, and in terms of client expectations, I'll add a little bit to that. So when someone's first encountering their medical providers, the scope of the treatment starts to become more clear.
Of course.
So when you do go to those specialists and they say, hey, that shoulder that's still bothering you, it looks like you're going to have a surgery. Mm-hmm. Or in other words, when it starts to become clear that the injury may be somewhat severe, require some sort of surgical intervention, or even a lengthy physical therapy, it's important that we know that.
Certainly.
So that we can communicate that to the insurance company right away, because they set the reserves on the case relatively early, a lot sooner than what most people think. Mm-hmm. Or at least they start to do that. They start the valuation immediately. And if the insurance provider doesn't know the severity of the injury, yep, if they're surprised by it at the back end, when that person's finally released from care several months down the road, they may not be able to go back to a supervisor and say, hey, I need an extra, $20,000 on this case because of the severity of it. And so you've basically created a situation where you're probably going to have to litigate that case. So that communication and knowing what's going on with the client right out of the gate is super important, because otherwise it's going to have some repercussions further down the road, which we'll talk about what it means if a case has to be litigated. So that's the first few weeks. Let's talk a little bit about the overall timeline.
Okay.
What can we expect the timeline or the process of an injury case to look like?
Okay. So I'm sure you and I field this question a lot.
Oh, yeah. When is my case going to settle?
Exactly.
Yeah.
And the timeline is a lot more difficult to pin down, but we can talk about the phases here, mm-hmm, so that someone at least knows kind of how the case will progress. And I'll talk a little bit about the timelines involved, but they do wildly vary, and we have to make sure that the client understands there are third parties involved here. It's not just us and the client. We have insurance companies, we have medical record providers, things like that. But to start off here, I would say it's first critical to note that there are two different levels of an accident claim. First is pre-litigation, where we're dealing with an insurance company, trying to resolve that in an amicable settlement that everybody's happy with and is what the client deserves. The second level would be litigation. So if negotiations fail, or there's any kind of contested liability, or they're contesting medical expenses, things like that, it's not going to give a fair settlement to our client, then we move into a litigation phase. So I'm going to primarily talk about the pre-litigation. Okay. Vast majority of our clients, their cases are going to be in that phase. Most all of our clients is going to be in that phase to begin with, at least. So we'll focus on that. There's several different phases within that level of a pre-litigation case. First would be intake and investigation. We've kind of touched on that already, but basically in that first phase, your attorney is going to be intaking your case, gathering information from you, gathering evidence from any other agencies that may be involved, such as law enforcement, building evidence and getting a case built around the facts of what caused the accident, the liability, things like that. That's going to be the first phase. The second phase is going to be medical treatment and records compiling. Okay, so as the client is treating, we're going to be following that treatment, discussing that treatment so we know how this person is progressing. But then we're also going to be ordering those medical records. Now, those medical records are not held generally by the actual provider. They're held by clearinghouses that handle all these records due to HIPAA and other privacy laws.
And that place might be in Tennessee or Texas. For some reason, they're always in Tennessee.
Yeah, they could be anywhere in the country, and they, are housing and compiling, millions of people's records. Mm-hmm. And so we have to send requests off to those that are compliant with HIPAA and other privacy laws, and those requests have to be then fulfilled and sent back. So as far as a timeline, this is where a lot of time drain can happen in a case, because generally we may see a record come back in 2 weeks to 2 months. Mm-hmm. Sometimes when we're following up on requests, we find out that they've mysteriously lost our request and we have to resubmit that request.
Or we know there's 10 dates of service, but they only send us 6.
Exactly.
So we have to send a second request.
Those. Yeah. So as those medical records are coming in, your attorney is also going to be reviewing those, mm-hmm, and making sure that there are no holes in the treatment or anything, or in the record or anything like that. So that's kind of that second phase is going to be as you're treating. That's another thing too, is this is wholly dependent on how much treatment a client has to get. So, some clients may go to an emergency room and they're able to recover with home treatment and, home remedies and over-the-counter medications. Some may have to have physical therapy or, all the way up to, like we talked about, a specialist in surgery and recovering from that surgery, things like that. So the timeline of a case is wholly dependent on the amount of treatment, but it also depends on getting those medical records.
Yeah.
So the next phase is going to be demand and negotiation. So once all the medical records are compiled and we have all the evidence as to the liability and the facts of the accident and everything like that, we're going to compile all those records. We're going to compile all the evidence we have. We're going to send that off as a whole package to the at-fault liability insurer, along with a monetary demand to resolve the case. And so that kicks off the third phase here of negotiations. As far as a timeline for a client to know, generally speaking, I'd say we probably get our initial offer from an insurer anywhere between a few weeks to a month or 6 weeks or so after they receive it. Now, that may depend on how involved the case is, how much records there are, how many records there are for them to review, as well as the caseload of that adjuster.
Right, which, as we've seen over the last year,
Yes.
That expectation has somewhat shifted dramatically because
Certainly.
Yeah, well, especially, summer of 2020, what happened was a lot of insurance companies furloughed several adjusters.
Mm-hmm.
So a case might have been transferred 2 or 3 times to new adjusters who had to reevaluate the case.
Exactly.
And then that adjuster all of a sudden got burdened with a huge number of new cases because once lockdowns started to lift and people got on the roads again and more losses occurred, you had more losses going to fewer adjusters because they had furloughed so many. And so you had adjusters that were overworked. And, it was an interesting time, to say the least.
I can give an example for you. I'll give you an example. This past summer, this was an adjuster with a major auto insurance company, and they were all working from home. Now, a lot of adjusters throughout the years have worked from home, but at this point during COVID, they were all working from home. And for her, this was an adjuster, she was a female, but for her region, which happened to be basically Florida, Georgia, South Carolina, North Carolina, and Virginia, they had one employee that would go in every day to their home office, I think in Virginia, to handle all mail, all faxes, anything paper that came in for all of these adjusters for 6 states. And so that can explain here how when we're mailing in medical records, there may be one person in an office who is receiving that, scanning that in to have it, disseminated to the actual
Those might
adjuster.
sit there for a week before that actually occurs.
Exactly. So that could be a huge time drain. And that's why it's so difficult to nail down the timeline. But hopefully now that people know, or a potential client knows the phases here, then hopefully they can understand, a case wholly dependent on their treatment.
Mm-hmm.
But short of that, there are some large chunks of time here that they need to understand have to occur.
So once we get into the negotiation stage and there's settlement offers being made, what does the client have to do?
So the client really just needs to listen to their attorney. We're going to negotiate those settlement offers to try to get to the maximum that we're able to get them to offer. At that point, and throughout the point, we're going to be discussing, throughout the negotiations, we'll probably be discussing multiple offers with them, obviously, because we cannot unilaterally reject one.
Mm-hmm.
But once we get to that maximum offer that the insurance companies, they're not going to open up the pocketbook anymore. And that's the amount that they are saying, that's our top offer. We're not offering anymore.
Mm-hmm.
And once we as the attorney are confident that that is their top offer and that it's now or never, the client is going to be, obviously would have a consultation with the attorney. And usually we are either going to recommend or not recommend that they accept that based upon our advice, our counsel, our expertise, and knowing all the ins and outs of their case, as well as the potential risks and rewards of litigation, go over all that with the client. And then it's their story to make. So they have to make the decision. We'll give you all the advice possible, but you're still driving the boat is what we kind of, we're the navigators, but you're still
the client's decision.
Still the client's decision. And so they'll basically make a decision. Do they want to resolve their case without the need of litigation, or do they want to move this into another phase, into the litigation phase, and possibly, all the way to a jury trial if necessary and things like that. If a client accepts an offer, then generally we say, a week to 2 weeks from there, once we receive a check and a release and we can have disbursement checks made and everything, then we'll have the client back in and we'll go over a disbursement of how the money's going to be going out, whether that be attorney's fee, any medical liens, any outstanding medical bills, and then the net proceeds for the client, and then they'll get their proceeds at that time. Mm-hmm. So that's kind of the process once it gets to settlement.
What are some reasons that a case may not settle?
Well, we've already touched on a couple, but contested liability happens a lot, and it may seem clear. It may be clear on a report from a police officer who investigated the accident. We see them a lot with intersections because we have yellow lights, you have turn lights, you have people in an intersection who need to clear the intersection on a left turn while the other side may be green. There's a lot of iffy areas. We see it a lot with medians or suicide lanes, turning lanes, and people lie.
People lie. After the fact, if there's no witness and they see that there's not a witness on the report, they'll say, oh, well, no, I didn't have the red light. I had a green light.
Certainly.
And that changes things.
So liability, those things happen. Mm-hmm. Contested liability. Not every case can be a cut and dry rear-ended accident. Mm-hmm. The second also is when I say an insurance company may devalue a client's injury, and they may devalue a client's medical expenses. Mm-hmm. We see this a lot where a hospital or a medical provider may charge more than what an insurer thinks they should be charging or what they're owed. And then also, they may be arguing over the mechanism of the injury, meaning that an accident may be not quite that severe, but a client or a patient may react differently, and we have to kind of watch out for things like that where not everybody reacts to the same forces. What affects an 18-year-old, kid may affect a 80-year-old lady differently. And
especially if there's some pre-existing injury or some other factor that makes someone more predisposed to suffering an injury. Mm-hmm. And that's another thing that we fight over all the time, though, is pre-existing and aggravated injuries.
Aggravated versus
where someone might have had minor back pain that they treated for a year before a loss or an injury, and then following a wreck, all of a sudden now they have severe back pain that's causing them to no longer even be able to work. Now you're going to have to fight and really hash out what was the level of pain prior and what is the level of pain post-accident.
Exactly.
And having that, before and after contrast is really important, because that's really what the insurance company owes. That's the extent of the damages, is the change. Mm-hmm. So even if you weren't at 100%, even if you weren't at zero pain, that client is still owed for the difference.
Exactly. And what we see a lot of, too, is acceleration of complications versus an aggravation. Mm-hmm. Say, for example, I've had a client who suffered a torn meniscus in their knee. Mm-hmm. And this client had arthritis in that knee prior. And the insurance company was wanting to resolve this basically just around the injury of a torn meniscus, which in itself is not that terrible. It's recoverable. It doesn't affect too much in a young person anyway. And this client was in their 50s, and we had to push and finally got a medical expert who explained to the insurer that her arthritis basically was accelerated between 15 and 20 years. So going into this injury, the knee of an average, slightly arthritic 50-something-year-old, on the other end of this torn meniscus, now the knee of a 75-year-old. And so that acceleration and everything was more than just an aggravation. An aggravation is temporary, but accelerating or worsening of an ancillary or maybe a side effect of an injury is critical to look at. So
true.
Yeah.
So if your case is one of those cases, and it's somewhat rare, but it happens fairly often, I'd say probably about 10 or 15% of the time, what changes once a case has to go into litigation?
Okay. And I'm not going to go too much in this. I know we'll touch on this more.
I think Charlie talked about that the other day.
I think Charlie did talk about that a little bit. But I'll say the two things that we like to explain to clients when it goes into a litigation phase is that the two biggest things that are going to change are the client's participation and the timeline. So when I say client's participation, we talked about earlier today, the client is the source of most evidence. And that is certainly true when it gets into litigation. Okay, so there may be written interrogatories, which are written questions under oath that a client has to answer. And there may be requests for production for documents or any evidence that a client may have in their possession. So the client is going to be directly involved in answering those questions and providing that documentation. The client will also be physically required, well, maybe in a normal year, but, physically required to come to a mediation, possibly come to a deposition, answer questions under oath. So their involvement is going to be greatly increased. And that could lead all the way to sitting in a box and testifying in front of a jury and a court. So the client involvement is increased dramatically, and then the other thing is the timeline is stretched dramatically as well. Litigation is basically it's formatted into deadlines, time limits, and everything like that. So whenever something is done, there's a certain amount of days before a response has to be done, and things have to be scheduled out. And when you bring into the fact that there are hundreds or thousands of other cases that are going through the same scheduling process, hearings, mediations, depositions, all of that can be pushed out due to scheduling conflicts. So the timeline may go from months to possibly even years of extending your case. Mm-hmm. So those are the two things that we like to make sure that a client knows just right out of the gate, if it's going into litigation, that their involvement is going to be increased and that the timeline is going to be stretched dramatically.
Yeah.
So, there's obviously lots of more ins and outs and risks involved with litigation and things like that, but those are the two that we always like to broach first as a subject when we're talking about possibly going into litigation, so that a client understands that it's going to directly change for them.
Well, we've covered a lot
in
a short amount of time. I don't want anyone to feel like they're drinking from a fire hose, so I think that's a good stopping point. But I think this is really helpful for people to understand what it means when they hire an attorney and what having a personal injury case kind of looks like and what those expectations are. But of course, if for some reason there's other questions or anyone has would just like to know more about any particular part of this, we like to be called by our clients. It's not a burden. So
of course,
please call us, talk to us, let us know what we can help or what questions we can answer. So
certainly.
Yeah. Well, thanks, Derek.
Thanks for having me, Joel.
Yep.
Thanks.